The title company called at 10:14 on a Thursday morning, and by 10:15, I understood that my marriage had not been ending. It had been liquidating me. I remember the exact sound my phone made against the granite countertop. One clean buzz while coffee dripped into the carafe and sunlight stretched across the kitchen floor of the house I thought was still mine. Maple hardwood, white cabinets, the blue ceramic bowl my mother gave us when we moved in. Everything looked ordinary, safe, domestic, the kind of quiet people confuse with stability. I almost let the call go to voicemail. Unknown numbers had become part of divorce life. Lenders, attorneys, spam, people who somehow smelled paperwork from a mile away. But something in me answered anyway. Maybe instinct. Maybe exhaustion. Maybe the small part of a woman that wakes up right before the floor gives out under her. Hello, is this Nora Whitfield? Yes. Ms. Whitfield, this is Andrea, calling from Northgate Title Services. I'm reaching out because we need clarification before closing this afternoon. Closing. That word should not have belonged to my house. I stood still, fingers around the edge of the counter. I'm sorry. Before closing what? There was a pause. Not long. Just long enough for a professional to realize she'd stepped into a room with the lights off. The sale of the property on Alder Creek Lane. My throat went dry so fast it felt chemical. That's my address. Yes, ma'am. We have you listed as a prior vesting interest. But the current file includes a transfer instrument and seller authorization from your spouse, Daniel Whitfield. We were calling because one document in the chain raised a notary inconsistency, and we need confirmation regarding your marital status at the time of transfer. I didn't breathe. Not a dramatic silence. Not a cinematic one. Just the body going primitive. Like every system shuts down to listen harder. I never authorized a sale, I said. Andrea stopped sounding like an employee and started sounding like a witness. Ma'am, were you aware the property was under contract? No. Were you aware of a quitclaim deed recorded 8 months ago? No. The coffee machine clicked off behind me. My divorce from Daniel had been final for 11 weeks. 11 weeks of split accounts, revised passwords, 2 court dates, 1 humiliating mediation, and a parade of people telling me to be reasonable about untangling shared assets. The house was the one thing I had fought over with my spine fully intact, not because of the walls, because of the money, because of the down payment that came from my father's estate, because of the mortgage auto-pays that had come from my salary for 6 years, while Daniel floated between ventures. Because every improvement to that house had somehow become ours in public and mine in private. Financed by my bonuses, scheduled around my work, scrubbed and staged and maintained by me, while he perfected the art of standing near expensive things like he had built them. In court, he had argued occupancy, contribution, sweat equity. His attorney used that phrase twice. Sweat equity, like moving patio furniture counted the same as wiring $40,000 from an inheritance account and paying property taxes on time for 6 straight years. The judge hadn't awarded him the house. Not cleanly. We were still waiting on final enforcement language tied to a refinance deadline and a reimbursement schedule. My attorney, Lila Moreno, had called it messy but manageable. Daniel had 30 days to cooperate on documents. I had 90 days to complete the refinance into my sole name. Until then, no sale, no encumbrance, no transfer without mutual execution or court order. At least that's what I believed. Now a title company in Bellevue was asking why my ex-husband had sold my house by afternoon. I put Andrea on speaker because my hand had started shaking. Tell me exactly what is in that file." She lowered her voice. "I can't advise you legally, but I can tell you what we have. A recorded quitclaim, deed transferring your interest to Daniel Whitfield, dated October 14th of last year. A listing agreement signed by him as sole owner. A pending sale scheduled to fund today at 4 p.m. There was also a payoff request on an existing line of credit." A line of credit, not just a sale. Leverage. I felt the room tilt a little. There is no line of credit. According to the file, a HELOC was opened against the property 7 months ago. I gripped the counter so hard my palm hurt. Daniel had always liked paperwork that sounded temporary. A bridge, a float, a short-term thing. He never called debt by its name. He dressed it in optimism and wore it like cologne. When we were married, he once opened 3 business checking accounts in 6 months for companies that never lasted past the logo phase. He loved entities, LLCs, draft plans, pitch decks, the image of movement, the language of inevitability. But a HELOC on the house required title, a recorded deed, a bank, a notary, a chain. Not a mistake, a system. Andrea spoke carefully. "Ms. Whitfield, I recommend you contact counsel immediately. We have placed a temporary hold on funding pending clarification, but I can't promise how long that lasts, unless someone sends us formal notice." I grabbed my phone and keys at the same time. "Don't close. Do not close. I'm sending notice. We've flagged the file, but please move quickly." The call ended. For 1 full second, the kitchen was perfectly quiet. Then I called Lila. She answered on the second ring with the voice she used for judges and frightened people. "Nora?" "The title company just called me," I said. "Daniel is selling the house today." Silence. Then flat and sharp. "Tell me everything." I told her, fast, clipped, every word hitting the air like broken glass. Quitclaim deed, pending sale, HELOC, notary issue, funding at 4. By the time I finished, Lila was already moving. I could hear heels, a car door. "Listen to me. Do not call Daniel yet. Do not text him. Do not warn him. Email me the title company info now. I'm sending a notice of adverse claim and demand to freeze disbursement." Then I'm pulling the recorder's file and the court orders. "He forged my name." "Maybe," she said. "Or maybe he found someone willing to notarize a lie. Either way, he's not walking away with sale proceeds today if I can stop it." If I can stop it. That was the first moment I understood the day would not be about truth. It would be about speed. I drove to Lila's office in downtown Seattle with my pulse in my throat and both hands locked on the wheel. Traffic on I-5 moved like it had all the time in the world. A landscaping truck, a Tesla with a vanity plate, a woman in sunglasses singing at a red light. Every ordinary thing felt offensive. Somewhere in the city, people were buying salads and answering emails and thinking their signatures meant something. By the time I got to Lila's building, she had printed the county recorder file and spread it across her conference table like evidence after a storm. There it was, my name, my forged signature, a quitclaim deed dated 8 months earlier, transferring my interest in 4127 Alder Creek Lane to Daniel Whitfield, a married man, as his sole and separate property. The notary stamp was from Tacoma. I had never been in Tacoma that day. I knew because October 14th was my mother's birthday dinner. I had pictures. I had receipts. I had been in Seattle by 6:30, wearing a green blouse and pretending my marriage was salvageable through dessert. Lila tapped the page. This recording date is 3 days after the deed date. The notary acknowledgement is sloppy. There's a missing witness block the title officer probably overlooked because Washington doesn't require witnesses on deeds the way some people think. But the acknowledgement language is messy. More importantly, she slid another document toward me. Here's the HELOC deed of trust. Daniel's name, sole borrower, $200,000 line, secured by my house, opened less than 3 weeks before he moved out and told me he needed space. I sat down because my knees stopped pretending. He borrowed against the house before the divorce? Yes. And no one told me? He represented himself as sole title holder because of this deed. She lifted the forged instrument with 2 fingers, like it was contaminated. The bank relied on record title. I stared at my own fake signature. He had tried to mimic the curve of my N and overdone the tail on the A. The kind of imitation that might pass in a stack, but not to the woman whose hand had signed tax returns, school forms for nieces, condolence cards, and payroll approvals for 15 years. He planned this, I said. Lila's eyes stayed on the document. Yes. There are moments when heartbreak changes species. This was one of them. Until then, the divorce had still lived partly inside the old language. Betrayal, resentment, ego, cruelty, affairs of power, if not necessarily of the body. But this was colder. This was infrastructure. This was him turning marriage into access. Access into title. Title into debt. In debt into a pending wire transfer he hoped would erase the trail faster than I could run it down. Lila opened her laptop. I've already emailed Northgate Title. I'm drafting Elias pendants and an emergency motion to enforce the dissolution orders. I want the recorder's office documents, court pleadings, and your specimen signatures side by side. We may also need a declaration from you today. Today? Yes. Before funding. Once money moves, recovery gets uglier. Ugly. That word felt too small for a man trying to pawn my future before lunch. She kept moving. Did Daniel ever ask you to sign anything around that time? Anything mixed in with refinance papers, tax documents, insurance? I thought about stacks on the dining table, envelopes, his habit of talking while sliding papers toward me. Sign here, initial there. It's just for the contractor. It's just clean up after the LLC filing. It's just bank housekeeping. I had become careful in the last year of the marriage. Suspicious, annoying, he called it, difficult. I stopped signing things without reading. It started more fights than I can count. No, I said slowly. Nothing that looked like a deed. Could he have scanned an old signature? Maybe, but this looks like a live attempt. I leaned closer, and wrong. Good, she said. Wrong is useful. Useful. Another lawyer word for pain with evidentiary value. By noon, the day had split into channels. Lila handled court and title. I handled memory. I sent her photographs of my real signature from my passport renewal, my driver's license application, the estate papers from my father, the original purchase documents for Alder Creek. I forwarded the court order drafts from the divorce. I dug out the settlement emails where Daniel argued he should be credited for the house because he had managed strategic financing options. At the time, I thought he was exaggerating his role. Now I read that sentence and saw a confession wearing loafers. At 12:43, Andrea, from Northgate, called back. Her voice was tighter now. Ms. Whitfield, we received correspondence from your attorney. We have suspended the file pending legal review. I closed my eyes. Thank you. There's something else, she said. The buyer's side is asking questions because the seller's urgency has been unusual. Of course it had. Daniel never played long games when he smelled cash. He lunged. What kind of unusual? He amended wiring instructions this morning. Lila looked up from across the room. Andrea continued. Originally, proceeds were to be disbursed to a personal account ending in 8821. At 9:52 a.m., we received revised instructions directing part of the seller net to an account held by Whitfield Strategic Holdings, LLC. I almost laughed, not because it was funny, because it was so exactly him. He had created an LLC to catch the money on the other side, a bucket with a business name. Lila held out her hand for the phone. I passed it over. This is attorney Lila Moreno for Ms. Whitfield, she said. Please preserve every email, instruction, call log, and document related to this file, including the revised wiring request and metadata on receipt times. I'll follow up with a written preservation demand. Andrea didn't hesitate. Understood. When the call ended, Lila wrote down the LLC name, Whitfield Strategic Holdings. Have you heard of it? I stared at the words. No. Then he formed it recently, probably to move proceeds and complicate tracing. The divorce had revealed many versions of Daniel. Charming Daniel, offended Daniel, financially misunderstood Daniel, wounded entrepreneur Daniel, the man who could turn a dinner party into a TED Talk about markets he had never entered. But the version sitting inside those documents was the one he hid best. The one who loved systems, because systems looked neutral while they carried out personal violence. By 1:30, we had a timeline. October, forged quitclaim deed recorded. November, HELOC opened. December through March, draws taken against the line in multiple tranches. April. Daniel filed for divorce, claiming irreconcilable differences with that soft, bloodless phrase the law uses when it wants furniture to seem more damaged than people. June. During discovery, he produced incomplete bank records. August. Final divorce order entered, leaving house disposition subject to refinance, reimbursement, and compliance. Today, house under contract for sale without notice to me, with proceeds routed in part to a fresh LLC. Lila looked at the board she'd built on the glass wall. Dates, arrows, entities, amounts. This didn't start when the title company called. That was just when the machine made noise. And that, more than anything, was what hollowed me out. All those months I had been reacting to the visible disasters, the sarcasm, the late-night absences, the mediation cruelty, the smugness in court. Meanwhile, there had been a quieter version underneath, recorded, stamped, underwritten, indexed, waiting to become real because paper doesn't need conscience to move. At 2 p.m., Daniel finally called me. I looked at the screen until it stopped. Then he texted, "Need to talk." I didn't respond. A minute later, "You are making this worse than it needs to be." Then, "You were going to lose the house anyway." Lila read over my shoulder, "Save everything." Another message. This was the cleanest option for everyone. Everyone. Men like Daniel love the passive voice when they're stealing. I typed nothing. At 2:17, another call came in, this time from a number I didn't know. Lila answered on speaker. "This is Lila Moreno." A male voice, polished and nervous. "Hi, this is Kevin Marsh, counsel for Daniel Whitfield. I'm hoping we can resolve a misunderstanding regarding a pending transaction." Lila's face did not change. There's no misunderstanding. There appears to be a forged deed, a concealed credit line, and an attempted sale of disputed property in violation of court orders. Kevin exhaled. My client maintains he had authority. Based on what? A transfer executed during the marriage. Then he can explain why my client denies signing it. Perhaps she forgot. Lila cut him off so cleanly I almost admired it. Counsel, do not insult me on a recorded line. A beat. Kevin recalibrated. I'm simply saying there may be factual disagreement. Wonderful, Lila said. Then we'll enjoy discovery. It turned out Kevin hadn't known about the wiring change to the LLC. I could hear it in the tiny fracture in his breathing when Lila mentioned Whitfield's strategic holdings. Another thing Daniel had not bothered to disclose to the man, billing by the hour to sound respectable. After the call, Lila said, his lawyer is behind the curve. Good. Good? It means Daniel is improvising. That should have comforted me. Instead, it scared me more. Improvising men do desperate things when cornered. At 3:10, we filed the emergency motion electronically and requested an expedited hearing for the next morning. At 3:26, Northgate confirmed in writing that closing was suspended pending court direction. At 3:40, the buyer's broker sent a furious email demanding explanation for title failure and hinting at damages. Lila smiled for the first time all day. Pressure from the other side helps, she said. A failed closing is not just embarrassment. It is cost. Movers delayed, loan locks extended, sellers exposed, buyers angry. The kind of friction that makes hidden actors visible because somebody suddenly wants names. At 4 p.m., the time the sale was supposed to fund, I sat in Lila's office and watched rain begin to stripe the windows over Elliott Bay. The money did not move. The house did not close. Somewhere, Daniel's plan stalled with its teeth sunk halfway into my life. I thought I would feel triumphant. Instead, I felt sick, because stopping the wire didn't restore the months, didn't erase the HELOC, didn't answer how many lies fit inside one marriage before the structure itself should legally count as fraud. Lila handed me tea I didn't want and told me to go home. Home where? I asked before I could stop myself. Not because I had nowhere to sleep. I was staying in a furnished rental in Fremont while the house issue dragged on, but because the word had changed shape that day, she understood anyway. Go somewhere with a lock you trust. We're back here at 7:30. That night, Daniel sent 8 more messages. I read them in order like pathology. You're overreacting. My attorney says this will get straightened out. You left me with impossible debt. You think because your dad gave us a boost that you own every brick. I did what I had to do. The market was right, and you were dragging this out. You always make everything a crisis. Call me before you destroy both of us. The last one stayed with me. Before you destroy both of us. As if I were the fire. As if exposing the wiring of the bomb made me responsible for the explosion. I slept maybe 90 minutes in fragments sharp as glass. At 6, I showered, put on a navy suit, and tied my hair back with hands steadier than I felt. There is a kind of fear that eventually burns into clarity. By morning, I wasn't grieving. I was inventorying. The hearing was at 9:30 in King County Superior Court. Daniel arrived at 9:12 wearing the charcoal suit he used to reserve for investor meetings and funerals. Expensive enough to imply order, neutral enough to deny vanity. He saw me in the hallway and gave me that familiar expression. Pity, shaped like superiority. For years, that look had worked on me. It used to make me explain myself. Soften. Aim for reasonableness. It used to pull me toward compromise because I mistook calm contempt for competence. Not anymore. He approached with Kevin half a step behind him. Nora, this is unnecessary. Lila moved between us before I had to decide whether to answer. Daniel kept going. The deed was legitimate. You signed it during the restructuring. What restructuring? I asked. He blinked once. Tiny pause. The refinancing period last fall. There was no refinancing period. His jaw tightened. You never understood the financing side. There it was. His oldest religion. If a woman questioned him, she simply lacked fluency in the sacred language of money. I looked him in the eye. You forged a deed, borrowed against my house, and tried to sell it through a shell LLC. Kevin flinched at shell. Daniel's tone sharpened. You don't know what you're talking about. No, I said. The title company does. For the first time, his confidence shifted. Only a fraction. But I saw it. Because fraud is boldest in the dark. Bring in neutral professionals, title officers, banks, county records, judges, and suddenly the performance has to survive fluorescent light. Inside the courtroom, the hearing moved fast. Emergency matters often do. Lila laid out the core facts with surgical economy. Disputed property, forged deed allegations, concealed HELOC, attempted sale and contravention of dissolution orders, immediate risk of asset dissipation. She submitted specimen signatures and the notary irregularities. She requested injunctive relief, a freeze on sale proceeds, prohibition on transfer or further encumbrance, expedited forensic document examination, and full financial disclosure, including accounts tied to Whitfield Strategic Holdings, LLC. Kevin argued factual dispute, claimed Daniel believed in good faith he had sole authority, suggested the deed was executed during a period of marital financial reorganization. The judge, a woman in her 60s with silver hair and the patience of a surgeon, looked over her glasses and asked the question that changed the room. Mr. Whitfield, she said, if you believed you had sole authority, why was the property not disclosed as separately titled during dissolution? Silence. Kevin answered for him. There may have been oversight. The judge lifted a hand. I asked your client. Daniel stood. I relied on counsel during the divorce. Which counsel? She asked. Another pause. Because there was no counsel. Because he had hidden the deed from his own process. Because good faith owners do not accidentally forget they alone own the most valuable marital asset in dispute. He tried anyway. It was a complicated period. The judge's voice cooled by 2 degrees. Complication is not an answer. Lila asked leave to question him briefly, and the judge allowed limited inquiry. Daniel took the stand with the posture of a man still trying to charm architecture. Lila started simple. The deed, the HELOC, the sale listing, the LLC. He denied intent, minimized memory, claimed administrative confusion, claimed he assumed the deed reflected discussions we had once had about protecting assets from business volatility. Then Lila placed a single exhibit in front of him. The revised wire instructions from the prior afternoon. Is this your email? Yes. Is Whitfield Strategic Holdings, LLC, your entity? Yes. When was it formed? Recently. How recently? About 2 weeks ago. And why were sale proceeds from the residence being redirected there? For tax and accounting efficiency. Lila tilted her head. Efficiency in relation to what, specifically? Business planning. Which business? He named a consulting venture I had never heard of. Lila nodded once, then handed the clerk a formation record she had obtained that morning. Your Honor, for identification. The LLC was formed 6 days before the scheduled closing, with Mr. Whitfield as sole member and manager. No prior disclosure in dissolution proceedings. No corresponding business income reflected in the records produced to date. Kevin objected. Overruled? Lila stepped closer. Mr. Whitfield, did you inform the title company that ownership of the residence was disputed under pending enforcement issues in your divorce? He hesitated. No. Did you disclose to the buyer that the property had been the subject of a recent dissolution order? No. Did you inform your own counsel yesterday morning that you had changed the wiring instructions? He looked toward Kevin. That was answer enough. The judge saw it too. By the end of the hearing, she entered temporary orders from the bench. No sale, no transfer, no further draws, no dissipation of proceeds from any property-related account, immediate turnover of HELOC statements, L per al C banking records, and a forensic handwriting review. She also set an evidentiary hearing 2 weeks out and warned Daniel in language so dry it nearly smoked. If the deed proves fraudulent, she said, the consequences will exceed property allocation. Not loud, not theatrical, but every person in that courtroom heard the word beneath the sentence. Fraud. Outside in the hallway, Daniel finally lost his varnish. This is insane, he snapped. Do you know what you've cost me? I turned toward him slowly. What I've cost you? The buyer is threatening suit. The bank is asking questions. Kevin is billing me into the ground. You could have handled this privately. Privately? Meaning quietly? Meaning with no timestamp outside his control. You tried to sell my house. He stepped closer, too close. It was never just your house. It is now. Something dark crossed his face then. Not rage exactly, but the insulted disbelief of a man discovering that the woman he discounted had learned to read the ledger. For the next week, the case widened. Once people start pulling on title, other things come loose. The HELOC records showed Daniel had drawn $183,000 over 4 months. Some went to obvious drains, credit cards, delinquent business rent, a luxury SUV lease he had hidden through a company account. But a large portion moved through transfers that looked almost professional, too tidy to be impulsive, too segmented to be accidental. Lila followed the wires. Whitfield's strategic holdings wasn't the only bucket. There was also Cascade Advisory Partners, inactive but open, a merchant processing account, 2 short-lived online brokerage accounts, a private lender payment trail tied to a failed restaurant investment Daniel once swore was already de-risked. Every few hours, another page came in, another account, another transfer, another version of him trying to convert house value into motion before anyone could call it theft. I stopped being shocked and started becoming precise. That was the shift. Pain had made me blurry for months. Documentation made me dangerous. I built binders, dates, amounts, email strings, screenshots, real signatures against fake ones, photos proving where I was when the deed was supposedly notarized, my mother's birthday dinner reservation, parking receipt, group photo time-stamped at 7:12 p.m. Daniel had claimed the deed was signed in Tacoma at 6:40. Lila smiled when she saw that. Good. A lie with geography is easier to kill. The notary became the next crack. Her name was Denise Holcomb, commission active at the time, office in Tacoma. When contacted through counsel, she initially stated she had properly witnessed my signature. Then Lila subpoenaed her journal. There was no journal entry for me. There was an entry for Daniel, 1 signer, male, real estate transfer. No female signer listed. No ID notation for me. No thumbprint requirement in Washington, but the absence of any corresponding record mattered. When Denise realized the gap, her story changed. Maybe both parties had been present, but she only logged one. Maybe she completed the acknowledgement later. Maybe she relied on familiarity. Familiarity. She had seen Daniel before. He had used her for prior business filings. By the second week, even Kevin looked seasick. The evidentiary hearing drew more people than I expected. Not press, not anything glamorous, just the ecosystem of legal collapse. Paralegals, clerks, a title representative, a bank risk officer, and the buyer's counsel, because now everyone wanted the court to decide whose disaster this was. Daniel testified again, this time under narrower, meaner light. Lila walked him through the chronology until chronology itself became accusation. You say the deed was valid, then why conceal it in divorce? You say the HELOC was marital strategy, then why was it not disclosed as existing secured debt? You say the sale was a practical resolution, then why reroute funds to a new LLC days before closing? You say this was misunderstanding. Then why did the notary journal not show my client? He tried to survive with tone. Men like him often do. They mistake confidence for a substitute for sequence. But documents are cruel to charisma. They hold still. Then came the twist, the one even I hadn't seen until the bank risk officer took the stand. Northwest Community Bank had opened the HELOC based not only on the quitclaim deed, but on income statements Daniel provided claiming ownership and occupancy status tied to Alder Creek. Standard enough on its face. Except those statements included rental income from a second property in Spokane that, according to the bank's internal review, Daniel did not own. Lila straightened in her chair. The officer continued. The Spokane property was actually held in the name of an irrevocable family trust established by my late father, with me as current beneficiary and successor trustee after probate closed. I felt the blood leave my face. My father's trust. A property I had barely thought about in months because it was a duplex managed by a local company, modest income, nothing flashy. Daniel had helped me review some of the trust paperwork after Dad died. I had assumed he was being supportive, organized, adult. Now the bank officer was testifying that Daniel had used trust-generated rent schedules in his HELOC package, presenting them as if available to his household liquidity profile, not titled in his name, not his asset, not even marital property in the ordinary sense. He had reached past the house, past the marriage, into my father's estate. It was like discovering a burglar had not only emptied your safe, but copied the family photos on the way out. Lila asked for clarification. The officer explained that while the Spokane property had not been pledged directly, the bank now believed Daniel used trust documentation and rent deposits to inflate repayment capacity and support underwriting. Those documents were under additional review. Fraud referrals had been initiated internally once the title dispute surfaced. Fraud referrals, plural. Daniel's face finally changed. Not anger, not wounded pride, fear. Clean, visible, unstyled fear. Because property division is civil. Bank fraud travels. The room got quieter after that. Kevin requested a recess. Denied. Denise the notary testified next and unraveled almost immediately. Under questioning, she admitted Daniel had come to her office alone more than once in past years. She admitted she had pre-stamped acknowledgments in rare situations for longtime clients she considered trustworthy. She admitted she could not say under oath that she watched me sign the deed in question. That was it. Not a confession with thunder. Just the small administrative sins that powerful men count on. Laziness, convenience, professional vanity. The assumption that rules are for strangers. By the end of the day, the judge issued oral findings strong enough to rattle the walls. She found substantial evidence that the quitclaim deed was invalid and likely fraudulent. She found Daniel had failed to disclose material facts during dissolution. She found the attempted sale was conducted in bad faith. She ordered the deed set aside pending final written order. The HELOC frozen and subject to allocation based on fraud findings, and all property-related claims preserved. She also referred the record to the appropriate authorities for further review concerning possible financial fraud and notarial misconduct. Daniel stared ahead while she read. For the first time since I had known him, he looked like a man hearing a world that would continue without agreeing he was special. Outside the courtroom, Kevin peeled off from him almost instantly. That told me more than any sentence could have. Lawyers stay close when strategy exists. They create distance when the file starts smelling criminal. Daniel tried one last time in the parking garage. He came after me while Lila was on the phone, footsteps echoing off concrete. Nora. I kept walking. Nora, stop. I turned because I was done being followed. He looked older than he had 2 weeks earlier. Not softer, just thinner around the eyes. You don't understand what happens if this goes farther. I almost smiled. There it was again. The thesis of our marriage. That I did not understand. What happens? I asked. He lowered his voice. Banks overreact. Regulators overreact. Once they start labeling things, there's no putting it back. I folded my arms. You mean once people start calling your actions by their names? It wasn't like that. You forged my name. He looked away. I was trying to stabilize things. For who? For us at first, he said quickly. Then for me, because you had already decided to blow everything up. That sentence might have shattered me a year earlier. Now it only clarified the architecture. He did not think he had stolen from me. He thought he had reallocated resources from a system in which he was the natural center. Marriage to Daniel had never been partnership. It had been authorized access. When I revoked access, when the divorce, the boundaries, the scrutiny began, he experienced that not as consequence, but as betrayal of him by the person whose labor, inheritance, and credit he had quietly integrated into his own self-image. You didn't want a wife, I said. You wanted collateral with a heartbeat. His face hardened. That's dramatic. No. Selling my house behind my back was dramatic. I walked away before he could answer. The final written orders came 5 days later. The forged deed was void. The attempted sale null. The HELOC remained a live problem, but no longer my silent one. Because once the deed was set aside, the question shifted from whether the debt existed to who had created liability through fraud and misrepresentation. The bank, suddenly much more interested in cooperation than bravado, negotiated through counsel. They wanted repayment pathways. They wanted exposure contained. They wanted to know whether they had a claim against Daniel, against the notary bond, against title insurers, against anybody whose negligence or lies could absorb the blast radius. For once, not every institution turned toward me expecting unpaid emotional labor. Some of them turned toward him. That mattered. The house sat in limbo through October, while Lila cleaned the chain of title and negotiated with the lender. I visited it only twice. The first time, I stood in the driveway and looked at the blue-gray siding, the trimmed hydrangeas, the porch light I had picked out at Home Depot on a rainy Saturday 6 years earlier. I expected grief. Instead, I felt distance, like seeing a photograph from a life that had belonged to a close relative rather than me. The second time, I went inside. Daniel had left behind a few things in the garage: golf clubs, an unopened air purifier, a framed print he used to claim was an investment because it came from a gallery in Portland. The house smelled empty in the specific way suburban houses do when staging furniture is gone and all the softness has been removed. Every footstep came back to me. In the kitchen, I put my hand on the same counter where Andrea's call had landed. 10:14. That was the moment the title company called. But it was not the moment my life changed. It was the moment the invisible became admissible. There's a difference. Women are often told they ignored the signs. I don't think that's always true. I think sometimes we saw them. The odd transfer, the evasive answer, the hurry around signatures, the mood shift when money entered the room. But we lacked a mechanism to force reality to hold still. And people love telling a suspicious woman she is paranoid until a neutral third party prints the PDF. A week later came the power reversal Daniel never imagined. Not because it was cinematic, but because it was administrative. The bank formally closed and accelerated the HELOC under fraud review. Their claims department pursued Daniel directly. The buyer from the failed sale filed notice of intent against him for misrepresentation and transactional damages. The notary commission complaint moved forward. Kevin withdrew as counsel. Daniel's temporary motion for access to his share of future house proceeds was denied, with language so blunt, Lila read it aloud twice for pleasure. Then the family trust attorney handling my father's estate contacted us with updated records. In reviewing the Spokane trust files after the bank testimony, he found old email correspondence showing Daniel had requested rent rolls, maintenance ledgers, and account summaries under the guise of helping Nora streamline her inherited property management. He had copied those materials into a financing folder months before the HELOC application, which meant the fraud wasn't opportunistic. It was layered. He had been gathering pieces of my life the way thieves test windows. Lila used that evidence to seek sanctions and fee shifting. We got both. The judge ordered Daniel to pay a substantial portion of my attorney's fees based on bad faith conduct, concealment, and litigation abuse. Whether he could pay was another matter, but the order existed. On paper, indexed, enforceable. Numbers changed character once attached to his name. Then came the house itself. Because the title had to be cleaned, and because I no longer wanted to live inside rooms where every doorknob felt like cross-examination, I made a decision no one expected. I sold it. Not in panic. Not because he had pushed me out. Because I chose liquidity over haunting. Northgate Title handled the closing this time, and Andrea called me personally before signing. Her voice was warm now, careful in a different way. Ms. Whitfield, I just wanted to confirm receipt of the final package and let you know we're cleared to close tomorrow at 11. Tomorrow at 11? A clean closing. My signature, my wire, my decision. I thanked her and sat with the silence after the call, letting it land somewhere deeper than relief. Daniel heard about the sale through counsel, of course. He objected to the distribution, claimed offsets, claimed contribution, claimed entitlement through occupancy history and improvements. Lila responded with spreadsheets so exact they sounded like music. Inheritance source tracing, mortgage payment history, HELOC fraud allocation, sanctions, fee orders, prior non-disclosures. The final numbers were not kind to him. After liens, fees, negotiated reserves, and protected distributions. The net that came to me was not the fairy tale amount people imagine when they hear house sale. It was better. It was clean. Clean money after dirty hands. I moved into a townhome in Kirkland with fewer windows, better locks, and no sentimental landscaping. Small enough to maintain a loan, bright enough to feel like future instead of aftermath. The first thing I bought was not furniture. Yeah, it was a fireproof filing cabinet. That sounds bleak, I know. It wasn't. It was peace with labels, a place for deeds, trust documents, tax returns, insurance, account passwords, the anatomy of ownership. People romanticize healing as softness. Sometimes healing is tabbed folders and a lawyer you pay before you need her. 3 months after the title company called, Daniel asked for a settlement conference on all remaining issues. He arrived looking like someone who had finally learned that charm does not compound like interest. His new attorney was younger, more realistic, and visibly uninterested in mythology. We sat in separate rooms while offers moved back and forth. By then, the criminal or regulatory side of his mess was outside my control. I didn't need revenge from that system. It would do whatever it did. What mattered to me was civil finality. No future claim to my father's trust. No interest in my accounts. No reopening of property matters. Full acknowledgement of fee obligations. Cooperation on corrective tax filings. Mutual non-disparagement, except as required by law. A clause barring him from representing any ownership, agency, or authority connected to my assets, inherited or otherwise. He resisted that clause. Of course he did. Because it named the core issue, authority, the belief that proximity had entitled him to signature space in my life. By 6 p.m., he signed. I was told later he argued over wording until the final hour, especially the paragraph addressing inherited and separate property. He wanted softer language, counsel-neutral language, something less humiliating. He didn't get it. The signed agreement stated plainly that he had no present or future claim, control, unmanagement role, beneficial interest, or authority of any kind over my separate property, trusts, inherited assets, or related income streams. Plainly, that word matters. The last time I saw him was 4 weeks later at a compliance hearing so brief it barely deserved the name. The judge confirmed the settlement terms, compliance deadlines, and outstanding fee obligations. Daniel answered, "Yes, Your Honor," in a voice that had finally run out of extra polish. When we stepped into the hallway, he didn't approach me. He just looked. Not with contempt this time, not even with anger, with the bewildered emptiness of a man who had built his identity around access, and discovered access can be revoked, documented, and filed. I walked past him without slowing down. Outside, Seattle was doing that strange silver afternoon thing it does in late winter. Bright clouds, cold air, streets still wet from morning rain, everyone moving with purpose under layers of neutral wool. I stood on the courthouse steps and called my mother. "It's done," I said. She was quiet for a moment. Then, very gently, "How do you feel?" I looked at the people passing below, strangers carrying coffee, backpacks, legal pads, flowers wrapped in brown paper. I thought about the call from Andrea, the forged deed, the notary, the HELOC, the buyer's anger, the bank's questions, the trust records, the courtroom, the numbers, the silence afterward. "I feel," I said slowly, "like I know the difference now." "The difference between what?" "Love and access," I said. "Support and surveillance. Partnership and extraction. Paper and truth." She didn't answer right away. Mothers sometimes know when a sentence has more work to do after it leaves your mouth. That night in my new townhome, I opened the filing cabinet and placed the final settlement order into the front drawer, next to the sale documents, next to the trust records, next to the corrected title chain for Alder Creek Lane. Everything aligned, labeled, dated, mine. Then I poured a glass of wine and stood by the window while the neighborhood settled into evening. A garage door opened across the lane. Someone laughed in the distance. A dog barked once. Ordinary life. Not flashy, not cinematic, just intact. People think the worst betrayal is being lied to. I don't. The worst betrayal is being used so thoroughly that the user begins to believe your boundaries are clerical errors. Daniel had believed that. He believed my inheritance was a family liquidity. My trust documents were household tools. My salary was marital atmosphere. My signatures were obtainable. My house was convertible. My patience was permanent. He was wrong. And the most satisfying part was not that he lost. It was how he lost. Not in some screaming showdown. Not because I outperformed him at rage. Because a title company called. Because a woman on a Thursday morning noticed a notary inconsistency. Because one professional did her job with enough care to ask the question men like Daniel count on nobody asking. That is what saved me in time. Not luck, attention, and once the question existed, once the chain was pulled into daylight, the rest followed. The county records, the banking file, the wiring instructions, the Shell LLC, the trust documents, the courtroom answers that could not survive sequence. The power reversal was never magic. It was documentation meeting velocity. The moment the title company called, Daniel still believed he was hours away from winning. By sunset, the sale was frozen. By morning, the court was involved. By week's end, the deed was collapsing. By month's end, the bank was calling him. And by the time it was all over, the house he tried to convert into escape money had become the very thing that exposed the architecture of his fraud. Sometimes justice is dramatic. Most of the time, it is procedural, stamped, filed, preserved, frozen, traced, voided. I used to think survival required endurance. Now I know better. Sometimes survival is answering an unknown number at 10:14 in the morning and refusing to let anybody else narrate what your signature means.